Good morning, everyone.
Good morning.
Welcome to the First District Court of Appeals. We have two cases that are set for argument today. Our second case is going to be a complete Zoom argument. So after this, the first case, we're going to take a break and we're going to go completely to Zoom, and that will be streamed over the internet like this one will be. We have Judge Zayas again is appearing with our new hybrid technology. Seemed to work out well yesterday, so it's the first week that we've been using it. So the first case that we have set this morning is case number C-23-0142. It's Ryan Olthouse versus Julie Neeson et al. We have, let's see, Mr. Gottesman will be arguing for appellant. And then so each side was asked for additional, I think the appellees asked for additional time to split time. We gave both sides 30 minutes instead of the usual 15. My understanding is that the appellees will be splitting the 30 minutes as they see fit. We have Mr. Sirkin will begin the arguments, and then we have Mr. Linneman, and then Mr. Larson.
Your Honor, Mr. Larson is evidently stuck in traffic, but is on his way.
Okay.
He should be here imminently.
Okay. And is he? And he's going to be arguing?
Yes, Your Honor.
And is he arguing third? Or,
yes, Your Honor.
Unless he doesn't make it. And then Mr. Whitaker.
Yes, Your Honor.
Okay. All right. Great. So, Mr. Gottesman, would you like to reserve any of your 30 minutes for rebuttal?
I would, Your Honor. I would ask the court to reserve 10 minutes for rebuttal.
10 minutes for rebuttal. I'll use the lights on the podium. When you have about a minute left, I'll put the yellow light on of your initial time. And then for the appellees, I'll just let you all I'll keep the 30. And you all can just decide amongst yourselves how you're going to do that, okay?
Is it the court's preference that I wait for Mr. Larson, or may I begin?
We're going to begin. It was 9 o'clock, so go ahead.
Okay, thank you. May it please this court, counsel, I'm here today on behalf of Cincinnati Police Officer Ryan Olthouse. This case begins with a lawsuit filed in July of 2020. That timing is important because it was sort of the peak of the defund the police and George Floyd uprisings that we were having across the country. So it was a volatile time, and that context is important. On June 24th, there was a budget and finance meeting at the city of Cincinnati, and Ryan Olthouse, as a Cincinnati police officer, was assigned to crowd control, and he was standing in the lobby, and he encountered Terhas White, a defendant. She was agitated, petulant, aggressive, and she was looking for a fight, and there's video evidence that proves that, a lot of it. Ryan Olthouse was being questioned by Ms. White. He made a gesture with his hand because it was a loud environment. He gave her what was an okay sign with his hand like this. She retold that story repeatedly, but she changed it. She said he was throwing racist gang signs in her face.
Well, so I guess I'm having trouble when you say she retold it but changed it. Like, she is interpreting a gesture made by your client, and there are multiple ways to interpret that. So how can that be the basis of a defamation claim?
So it is, when you see the video, when you see what actually happened, and you understand that she's making a claim that in the discharge of his professional duties as a police officer, he's throwing racist gang signs in her face. That's the allegation she made. And that is not what happened. That is not even remotely what happened. And that's the lie.
But
That's the untruth.
But you acknowledge that there is a double meaning for that symbol.
I don't, actually. I understand that there's, a fringe lunatic group out there that it could twist anything we say or do. Literally, I can say virtually anything.
Well, but that's part of the issue here is there are certain, leave gestures aside, there are certain words that have double meaning, and if you utter that word, you may mean it in one context, but I may interpret it in another context. It doesn't change the fact that you said the word.
That's right.
What changes is what the perception of it is, and that's the issue that I think from a defamation standpoint, how can that be defamatory if it's true that you said the word?
Because there's a difference between making an okay symbol with your hand and stating that, or making a white power symbol with your hand and being a uniformed police officer throwing gang signs in a speaker's face.
So
Those are two different ideas.
We have the okay sign, and then are you saying there's some sort of allegation that he did other signs as well, or are we only talking about this okay sign?
The okay sign.
Okay.
Ms. White's contention is that the okay sign, this gesture that I'm making right here with my fingers, is a white power sign being thrown in her face to intimidate her.
And you don't
as a speaker.
but you don't acknowledge that symbol has been interpreted as a white power symbol. I mean, I thought that was kind of agreed upon in this case.
I've certainly seen that.
It has been.
People have said that, yes. I mean, they've cited such nonsensical sources as the Southern Poverty Law Center. That is just an inflammatory group that is, monetizing racial grievance, and it's meaningless. What he did that day and what he's accused of doing are two totally separate things. He was discharging his duty as a police officer politely, respectfully, in a professional way.
Well, but I think but this is part of the issue, is like, you say he was polite and respectful. She says he wasn't. I mean, these are the gradations in someone's conduct and the interpretation of another person who's there. Their interpretation could be totally wrong, right? Maybe he was being polite and she says he was being rude. But ultimately, that doesn't rise to the level of defamation. What we're looking at is, was there a false statement that we can point to and we can verify as false? And I think that where the trial court went was saying that this is opinion, and I don't see anything in your brief that really tackles what the trial court was saying here.
So the tackling is this: throwing gang signs in a citizen's face is a fact, not an opinion. That's a fact, not an opinion. Accusing him of throwing gang signs in her face is not a matter of opinion. That's an allegation of fact.
But she says that he made the okay sign, and she interprets it. This goes back to my earlier question. She interprets it in a specific manner, which may be totally wrong. But if she's saying he made that sign, and he acknowledges that he made that sign, then, and maybe we're just talking in circles, but how does that rise to the level of a false statement of fact?
So because he was standing away from her, he was standing across the room on a post. He didn't approach her. She was, and it's all captured on video. He's several yards away from her. She asks him a question, and he responds. That is not a matter of interpretation. That's what happened. Those are the facts. What she said is he was throwing racist gang signs in her face. Now, those are two entirely different factual ideas, and they're distinguishable.
It's a fact that she said it, but that was her opinion of what that sign meant, right?
No, I mean, to say that he was throwing gang signs in her face is not at all what happened. He was away from her. He went nowhere near her face. He didn't approach her. He did nothing to intimidate her.
I guess I'm sorry, but like this notion about the distance between them doesn't seem to be part of the allegations of the complaint.
Perhaps it was not, that specific factual averment wasn't included.
The defamation here is, your allegation is that he was defamed because he was called a racist,
No,
right?
that's not right.
Okay, what?
No, excuse me, Judge, I didn't
What-
mean to jump on you like that.
Just tell me
The
what it was.
allegation that we contend is defamation per se is that Ryan Oldhouse was throwing racist gang signs in uniform during the discharge of his professional duties. That's the allegation we call defamatory, because that allegation renders him unfit for his job and has career-damaging implications, and in fact did. He was taken off a preferred assignment on the gang squad. He was subjected to multiple nonsensical CCA complaints, and that it had real-life consequences, especially when the other defendants picked it up and started running with it. You had Mr. No threatening to disseminate his personal identifying information solely for the purpose of harming him. And you had others jumping on, piling on to cause him and his family harm. His home had to be put under surveillance by police. I forget which unit it was, but to watch because of credible threats against him and his family, based on a complete fabrication by Ms. White. And if you go back to what happened at the beginning, Judge Shanahan granted a TRO, ordering that no dissemination of his private information should occur, that they were enjoined from doing that. Inherent in that ruling, or underpinning that ruling, she had to find that there was a substantial likelihood of success on the merits. There was
But then she ruled against you.
I know, and I think that was a culmination of a lot of things. Because this case had
Yeah, and let me ask you this, going back to, like, part of the challenge, and I think it's part of what she was grappling with, was how do you prove or disprove that someone is a racist? I mean, it is obviously a very inflammatory accusation, and it can have real harm to people. But if someone says, I'm a racist, someone else is a racist, like, how do you prove or disprove that? I think that gets to the opinion nature of the accusation.
You really hit the nail on the head, though, and it's not opinion when you're applying it to a police officer in the discharge of his professional duties.
But why does that matter versus me or anybody else?
It matters because of the definition of defamation per quad or defamation per se. There's defamation per quad. You call somebody a racist, it's a matter of opinion. It's not actionable unless, and the Supreme Court has said that that sort of language, calling somebody a racist, is not provable, and it's, therefore cannot serve as the basis for a defamation claim. However, defamation per se has a provision, the third part, if it's, excuse me, I don't want to misquote it. It says,
Having a tendency
to
injure the plaintiff?
Yeah, in the course of his employment or
Trade
his
or
professional. And it's the Williams case that this court decided in 2005 that found for an officer who, it was said, in paragraph 10 of that Williams case is particularly instructive because this officer was accused of being related as a parent to a criminal defendant. And the court focused on whether or not that relationship to a criminal defendant could have adverse employment implications, hamper opportunity for promotion, or otherwise harm him professionally. What Terhass White started that day harmed Ryan Olthouse professionally.
But you're still skipping the initial determination of whether it was actually a false statement of fact or whether it was an opinion. Don't you have to decide that first?
Except I have video from City Hall's foyer that shows that what she said is false. He didn't throw any gang signs in her face.
In her face?
Right.
But was there an okay sign made?
Yes.
Okay.
Well, but I guess what I don't understand is, and I was a little bit confused by the distinction that you're drawing between defamation per se and per quad. Like, I get that, but was anyone arguing this was defamation per quad? I mean, it seems to me this is defamation per se, or it's not defamation.
That's right. I agree with you on that.
Okay.
And we've maintained all along that the defamation claim and the false light claim is a per se type claim because of its look, if he wasn't in uniform, imbued with the imprimatur of the state behind him, having the power and authority of the state or the city behind him, yeah, this doesn't matter. But because he's a public figure, because he's a police officer, because he's vested with this responsibility to discharge, his duties professionally, free from bias, free from race. I mean, racial bias is a disqualifying characteristic in a police officer. I think that's pretty widely accepted. So when you attack, and at that time of George Floyd, that was, one of the worst disqualifying characteristics you could assign to a police officer. So to say that about this officer when it's totally untrue, and we were stopped from presenting the case. We had his teammates from the SWAT team and from the gang unit, numerous black officers were willing to come forward and attest to the fact that this man engages with black citizens all the time, never conducts himself but in the highest order.
But this gets back to, how do we prove someone is or is not racist? What does that trial look like?
But listen, it is the question is not whether he's a racist. That is not the question, and it's never been the question.
But that's what you just were saying, that you were going to bring witnesses in to testify that he wasn't a racist.
I would bring in witnesses to testify that it would be outside his character to throw a racist gang sign in a speaker's face. And we'd have video to prove that. And they would counter that he is a racist, and he meant to intimidate her. And all the balance of all evidence would be against them on that point. And we were deprived of that opportunity.
How does that defeat the interpretation by the defendants in this case that how will that defeat the fact that they equate this symbol with a white supremacy symbol, and that's what they thought at the time?
Thank you for asking that question, Judge Krause, because various social media posts by Terhass White are marked as Exhibit 3. They're in the record. They were attached. It's Exhibit 3 to Ryan Olthouse's affidavit. And the way you know that she knows that this is not a racist gesture is because one of her many social media posts is an African-American woman posing like this. And she's got it up on her page. Now, therein lies the interpretation by her. It's fine for her to do this, or for her to post someone doing this. You really have to look at that exhibit. It's Exhibit 3 to Ryan Olthouse's affidavit. It's the last page of it. And as I said, it's this African-American woman posing like this, which, if that means white power, she would not be doing that. If she was offended by that, she would not be doing that. And that's evidence that she knows that's not what that means.
So that was what the trial was going to focus on, was to demonstrate that these people knew that that symbol does not mean that.
They were out to antagonize, to persecute, to attack a cop. That's all they were out to do. There's no higher order here, no public speech thing. It was the defund the police, it was antagonistic to police, and they went after somebody who served the city with, distinction and honor, and they smeared him, and they damaged his career, and they did it based on a lie told by Terhasway. And it was intended to hurt him, and it did. And whether it's Mr. No's intention to disseminate his personal identification information just to harm him, that's got to be a tort. It's got to be a tort. And Judge Shanahan enjoyed it.
Well, she also had issues.
Good morning. Good morning. I have a couple of questions.
Good morning, Your Honor.
Good morning, counsel. How are you this morning?
I'm good, thank you.
All right. So I have a couple of questions with regard to your initial filing of the complaint. Were there any attachments to that filing?
We filed a complaint with an affidavit. So it was accompanied by an affidavit because it was a request for injunctive relief. Rather than submitting a verified complaint, we opted to submit an affidavit in conjunction.
Okay. And with regard to the trial judge, one of the basis for the granting of the 12B6 was she found a deficiency in the pleadings with regard to the requirement to plead malice. How would you address that portion?
Paragraphs 60 and 64 of the complaint specifically aver that these actions were taken maliciously. Now, I recognize there's a distinction between maliciously and with actual malice as required under the law. However, I think that's taking a hypercritical analysis of the pleadings. For notice pleading, again, to the context of this matter, we were under the gun to enjoin the dissemination of this officer's personal identifying information because it was the obvious intention of the defendant, or at least defendant No, to circulate that information to harm this officer. And we wanted to jump on that quickly. So, after we filed that initial complaint in a hurry, then the matter proceeded. There was a TRO granted. Then it came to this court. This court, in fact, you two judges were involved in dismissing that appeal because it was not an appealable order. The appellees then were able to get the Supreme Court to accept it for review, and after argument in Columbus, the Supreme Court dismissed it as moot. So then it was back in front of Judge Shanahan, and the defendants immediately filed a motion to dismiss. So there's been no opportunity really to take any motion practice or other than the motion to dismiss. We were denied an opportunity to amend the complaint. And one last point, Your Honor, excuse me, I'm not sure if Judge Zayas, if I fully addressed your question, but there's...
Well, you sort of did. I mean, you did to a certain extent, and I understand your argument. The challenge here is that, malice is a required element, and it has a very specific meaning in the context of the defamation. While malicious, is a term that has a very different and much broader meaning.
But I believe if somebody acts maliciously, that can also be considered actual malice for purposes of defamation. If you intend to hurt somebody without regard to the truth or falsity of what you're saying, I think that satisfies the actual malice requirement for defamation.
And you are over your time if you want to reserve. You can answer all these.
Acting with malice?
I'm sorry, Judge Zayas, I didn't hear the first part of your question.
That acting maliciously can also exclude acting with malice, that it doesn't necessarily mean that it's acting with the knowledge that it is false or with reckless disregard.
I agree with you on that.
And I think that's the challenge. And so I also understand that you have assigned error to the denial of the motion to amend.
Yes. And one last, I would like to cut into my reserved time.
No problem.
There's one other claim that was pending that's been completely unaddressed, and that is Revised Code 230760 allows for civil liability for criminal acts. And there is a statute that makes it a crime to file a false report. It's 292115. Makes it a crime to file a false report regarding an officer in the discharge of his professional duties. Claims were made against Defendant White and Defendant Gilley for their false complaints against Officer Oldhouse. And that claim under 230760 was dismissed without comment or discussion by Judge Shanahan. I think that claim should survive the motion to dismiss challenge, and we were denied the opportunity to proceed on that.
Was that the complaint that was filed with the citizens, and the rest of the name is escaping me?
Yeah.
Is that what?
It is, Your Honor. It's the Citizens Complaint Authority in Cincinnati.
Thank you, the Citizens Complaints Authority. So how would you argue that the Citizens Complaint Authority, by filing a complaint or petition, that's akin to a complaint as if it were filed in a court of law?
The statute, the underlying criminal statute 292115 does not in any way limit or describe the forum where the complaint has to be filed by the person charged. Anyone filing a false complaint could be prosecuted under that statute.
But it has to be subject to the First Amendment, right? Because, you can't supersede the First Amendment.
Correct. Okay. Obviously, the First Amendment's supreme. However, that said, if you can prove knowing falsity when a charge is filed, I think and I think that's a question of fact. Okay. I really do. And listen, many of the claims here that were disposed of, summary judgment, I think that's a totally different question. But a 12B6 motion, I think that the judge was premature in making this decision. So thank you all. I appreciate the opportunity to present that, and save the balance of my time for rebuttal.
You'll have 5 minutes for rebuttal.
Thank you.
All right.
If it pleases the court, I'm going to address Judge Zaya's question. The statute requires, I think the case law, when we cite it, it's got to be a verified complaint that's made by an individual, and it's got to follow the rules of Criminal Rule 3. I think it's Criminal Rule 3, which requires it be verified, a verified complaint. That conclusion leads to the idea that it's got to be...
I'm sorry, Mr. Shurkin. What exactly what has to be verified?
Making the complaint to the Citizens Council.
You're saying that under the statute 292115, it has to be a verified criminal complaint?
Yeah, I think so. And I think or at least it has to follow the form of Rule 3A of the criminal procedure. And that means it's got to be verified. So the complaint, and so there's no, under the circumstances of this case, there's no way that that's applicable because the citizen's complaint is not verified. And that's a fact. So, there's no, that cause of action does not exist. The other thing that's...
And let's say that I were to agree with you, the argument this morning is that perhaps the dismissal at the 12B6 juncture was premature. So even as you're addressing this, I don't know what the procedure of the Citizens Complaint Authority is. I don't know whether it's verified or not verified. How would you address that perhaps it was a little early to dismiss at the 12B6 juncture?
No, it would not have been. It would have had to have been raised in the complaint. In the four corners of the complaint, it doesn't say that it was a verified complaint, and it doesn't give any facts about it. It just says a complaint was filed. It's their burden to prove that, that's a fact that he must set forth in the complaint. On its face, it doesn't It doesn't have.
Under the statutory claim, you're saying?
Yes, on the statutory claim.
And you're saying 292115 requires the verified complaint?
I believe it does.
Okay.
And I think there's
What
case
you're
law that-
arguing is that in the pleadings, it should have used the term verified complaint.
The complaint does not use the term that a verified complaint had been filed with the CAC.
Right, but now we're going beyond the filing of the complaint to get to that point. So on the 12th, if I'm looking at this through the lens of the 12b6 and solely through the lens of the 12b6, with the filing of the complaint of the action before us, what was the deficiency that would have allowed for it to be dismissed as a 12b6?
That's an essential element to that cause of action. And if it's not stated in the complaint, you can't substitute it. He could have amended it, but it's not in there. And
Okay,
with
well,
that, it's
that's
facially
what I said.
inadequate.
You must have misunderstood, because that's what I had said earlier. Are you saying that the deficiency is in filing the complaint, that he didn't use the term verified complaint?
That's right. I agree.
Okay, you agree with that, all right. It seems, when I looked at the record, I found it a little bit confusing with regard to the filing of the complaint with the matter before us. From your perspective, what was filed with the complaint, if anything?
Nothing. There was a motion for temporary restraining order that was filed that had an affidavit to it, but there's no reference in the complaint that refers to that affidavit for the TRO. That's a separate document, and it's not on the face, and that issue has been completely resolved. And, and it went up to the Supreme Court, and then ultimately the court disagreed with the finding, the minor finding by the court, at least as to the issuance of the TRO on the information should be disclosed.
Mr. Serkin, I'm looking at 292115B, and it says, no person shall knowingly file a complaint against a peace officer that alleges the peace officer engaged in misconduct in the performance of his duties. But I don't see anything about a verified complaint. Where would that be?
They said citations in our complaint, in our brief, cite to the cases that require the verified.
Is that the only thing that is lacking, in your view, of that allegation, or was there other missing?
The First Amendment.
Oh, okay, well.
And the freedom of speech provisions of the Ohio Constitution.
Okay.
Look, this is a public issue.
Yes.
And there was a lot of, what is being asked by the plaintiff here is to silence people making statements regarding public issues and public officials. We have not talked about the fact that a police officer is a public official for the purposes of defamation and actions and invasion of privacy and all that, because you want to really get discussions going. And there's no way that number one, you have to show the actual malice, which means got to be a reckless disregard in a way of, you got to actually know that the statement is false or be reckless in that regard. There's no question that that sign has been used as a symbol of of white supremacy. And so, therefore, and it's simply a matter of opinion, and the case is closed. There's no way that it's not protected by the First Amendment. He is a public official. Number two, it's a public issue. And number three, it's a statement of opinion. And a person has the right to that. What's happening here, I'm allowed to criticize police. I'm allowed to call him a police officer a pig. And that was the big name in the 70s. That didn't open you up to defamation. And so you're telling people that you can't give opinions of what you think something was said by an officer or what you believe about it. And it doesn't make any difference how much she likes or dislikes police officers. She's got that right. I can say a lot of things to a police officer and not be punished for it or charged with disorderly conduct or any violation of the law. It is protected. It's bottom line.
It sounds like what the appellant was arguing is that your client somehow knew that this was not, in fact, a white supremacy symbol when this was published on the internet.
I mean, it's an opinion, and it doesn't. You can't say that she didn't know it was, and that's not because it's a public official. And if he doesn't know, how does she know that it's not? Or how do you prove that? And it's their burden. It's their case, and I think we have to keep that in mind. This is a public issue. This is public hyperbole. People are allowed to use it.
Can I ask, as far as the pleadings are concerned, on the use of the word malicious versus malicious intent in the complaint? If they had said malicious intent, would that have been sufficient?
No, it's not malicious intent. It's got to, the malicious is defined as you've got to be acting knowing that your statement is false, and that you were reckless in in not going out and verifying it. The Williams case that he cites, that was a fact. You could look at the docket. That was a fact that he was not the son of that person, and that could have been verified if you look, because his last names were really different. So,
But didn't that just collapse on the opinion argument, ultimately?
but no, it's not an opinion where you can verify the fact. You can't verify the fact about whether somebody's a racist or not.
That's what I'm saying.
Yeah,
That's
it's an opinion. I mean, those terms are used all the time in political debate. They're being used. They're being publicly said today.
You have fact versus opinion. I mean, the judge was looking at a couple different things: fact versus opinion, and also whether the malicious intent was properly pled, right?
Right. And we believe it lacks on both. One, there's no way, there's not a proper pleading about the malice, and secondly, it's an opinion.
Well, so that's my question, though. How would you properly plead, in your view, malice? I mean, they use the word malicious in this complaint. How would that be properly pled?
Well, they'd have to probably use the terminology that with knowing that this statement was a statement.
And that's
that
all
was
they'd
a-
have to do
was a
is just
fault.
use the terminology.
I would assume that might be, but it's not pled in the complaint. And secondly, it's an opinion, so it really doesn't, that's not the only
You don't get there
essential
then
answer.
if
You don't get
it's
there.
determined it's an opinion.
Thank you. I'll turn it over to Mr. Lennon.
Morning, Judges. Rob Linneman, and Mr. Sirkin may have neglected to mention that I represent Terhaus White and Alyssa Gilly, as does he. We're joined by our co-counsel, Eric Larson, who represents Julie Neeson. We're joined by Justin Whitaker, who represents James Noe. I would like to follow up on your question, Judge Zayas, because it ties in a couple of the things that are important here. My charge among my colleagues was to address why the pleading should not be permitted to be amended after dismissal. But along the way, we're going to touch on a couple issues that members of the court have touched on. So first, Judge Zayas, I want to answer one of your questions first. There is nothing attached to this complaint. The complaint contains...
Can you please explain that to me? Because unfortunately, Attorney Sorkin wasn't able to get through that response.
Well, what I can explain to you is what I see on the docket and what was served upon the defendants in this case, and it is a complaint with no exhibits. It is a series of, it is text only. Now, that's important to your question too, because the CCA procedure, I'm going to go now to the question of the statutory claim for civil recovery based on the commission of a crime. Because you mentioned that the court might have questions about CCA procedure, but those questions are answered, as they must be, on a motion to dismiss by the allegations in the complaint. So the court must look to the complaint to see exactly what the plaintiff here is alleging, and the plaintiff has obliged. The plaintiff provided specific descriptions of what they deem to be objectionable within the complaint. Those allegations do not meet the standard of 12b-6. That is what Judge Shanahan made her decision on in order to dismiss that claim. Now, her decisions, as Judge Krause, I think you got to this point, they were in layers. On the one hand, the trial court ruled that this is political speech of the highest order in a place that's taking place in a nationwide debate over the specific issue being discussed. There's no question that Judge Shanahan's first ruling was this is protected speech, political speech of the highest order. It is core First Amendment activity. Second, it is opinion. It is difficult. The statements that are made here, Judge Zayas, to your point, as set forth in the complaint, the plaintiff has given us the benefit of telling us exactly what are the purportedly false factual statements that would meet the burden here. And so we looked at the complaint for that, and they come down to statements which might be considered name calling, but surely are not susceptible on behalf of all four defendants of ascertainment of whether it is true or whether it's false as a matter of fact.
And how does that analysis overlay with the statutory claim under 2307?
Okay, so to
Or does it?
To get to the point that, well, it does eventually. I mean, the defect at the pleading level for that claim is, to get to a point you addressed, Judge Bergeron, the statutory language requires the filing of a false complaint. The courts and the cases that we've cited, which include trial courts and courts of appeals around the state, have interpreted the word complaint, which is in the statute, to be to require a complaint as defined by Criminal Rule 3. Criminal Rule 3 requires a sworn statement. And the complaint does not allege that a sworn statement was made.
But I guess that's where I was trying to press Mr. Serkin a little bit. Like, I don't see anything about verified complaint Rule 3 in the statute, so how are these courts getting to that conclusion? Like, what is the basis in the statutory language that compels that conclusion?
Well, the explanation is it's a fairly straightforward step by analysis that was provided by one of the courts in the cases we cite, and it goes like this. I mean, basically, the statute says complaint. The court asked itself just what you were asking. What is a complaint? The court then said, well, is there a place where complaint is defined? Well, this requires a criminal offense, so we look to the rules of criminal procedure. Criminal Rule 3 defines how a complaint must be set forth. It requires a sworn statement. So from the statute to the rule, in order to meet this barrier, because to Mr. Serkin's point, if just any time anybody, let's say, complains, if that term is to just mean complain, speak negatively, offer some offhanded remark, then
right, but
we
I
run
think
into First Amendment issues.
The flip side is, under your interpretation, how many people are out there filing complaints compliant with Rule 3 to complain about police officer conduct? Like, nobody.
Well, that's the intent, because precisely as you said, this criminal statute must give way to the First Amendment. Any errant statement about
Well, that's a different
police
argument.
officer-
Like, what I'm focused on right now is, under the statutory interpretation, how do we know it's a complaint under Rule 3? And that's my point, is that if that were true, I don't know how often would that happen? Almost never. So then are we stripping the statute of, like, the basic gist of it?
No. According to the Court of Appeals, the way the Court of Appeals have interpreted this before, we're giving life precisely to the intent of the legislature. The legislature used the word complaint. The legislature knows what the word complaint means because it's in Criminal Rule 3. The courts have defined for the legislature in advance of that what constitutes a complaint, and the legislature also didn't want for a civil cause of action to arise every time somebody in a bar somewhere complains about a police officer falsely, in the opinion of that officer. Because another aspect of this, and I'll get now to why why.
Well, it says knowingly file a complaint, so I don't think someone
What does file
airing
mean?
grievances in a bar is going to qualify.
Well, if we don't know what complaint means, I would say subject that to the same analysis that you're subjecting the word file to, right? If we don't know what complaint means, but I think where I really want to go with this is that is intentional on behalf of the legislature. Filing a complaint means something. The complaint is defined within within the rules that already exist. That's what the courts of appeals who've interpreted this have found. And their analysis, by the way, it didn't separately say this is the First Amendment. This is on First Amendment grounds, but it incorporated First Amendment principles to imbue meaning to the legislative action there. Now, but the reason why that doesn't matter is because the plaintiff has been good enough to tell us what was in the complaints, and Judge Shanahan separately ruled that was opinion. Therefore, that could not form the basis of a complaint that could under which liability could arise. Then should this court grant leave to amend, or should the trial court have granted leave to amend? At that point, the standard of review that this court observes is different. And at that point, the trial court's standard is different. So first of all, the standard that this court will apply to the question of amendment is abuse of discretion. It's no longer de novo. And at that point also, the trial court is not confined to the four corners of the complaint. The trial court can look at other things that are in the record. Now, the plaintiff did not do the trial court the service.
But typically, you need an amended complaint, a proposed amended complaint for the trial court to evaluate, and that didn't happen here, right?
That did not happen here. So the trial court was left to determine what exactly would the plaintiff be offering. But the plaintiff had already submitted copies of the CCA complaints under the affidavit that he referenced earlier. So the court had the benefit of the CCA complaints. The court could look at them. And Judge Zayas, to your question, the court could know they were not sworn. They are submitted by email. They contain no jurat. They are not sworn complaints. So under Rule 3, they do not meet the definition. They therefore do not meet the statutory definition. They cannot form the basis of civil liability because they cannot form the basis of a criminal offense under the criminal statute. And all of those points are again, this court should recall, again, the difference in the standards on the rule to amend. So the trial court's decision was entirely defensible and sound for that reason. The complaint tells us the court was entitled to, and in fact obligated to, rely on the allegations of the complaint. The plaintiff gave the court what it wanted in very succinct terms in the complaint. But then, once the court had found that those statements, as articulated by the plaintiff themselves in the complaint, were either opinion or were protected speech, then the court was entitled to look beyond the complaint to determine whether it should give leave to amend or not. I have taken up more than the allotment that we agreed to among my co-counsel, so I'm going to defer now.
And I do have a couple more questions before you leave, please.
Okay.
I want to go back to something you said very early in your argument, and as I understood it was when you look at the complaint as it stands, that that which is complained of with regard to your client it cannot be verified as truth, whether it was a fact or a non-fact. Something to that effect you had said.
Oh, okay. Well, yes. That's when the court looks at the complaint, because the plaintiff didn't provide the actual statements. Now, all the online posts, by the way, all the statements that are at issue here are in the record because they submitted them under an affidavit separate from the complaint in an effort to obtain injunctive relief on a temporary basis. So this court, in reviewing the question of amendment, has that in the record and can consider it. But to your point, Judge Zayas, the court should evaluate, for terms of First Amendment muster, the statements that were made as they are articulated within the complaint. In each of those, they come down to just a couple paragraphs for each of the defendants in which the plaintiff has specifically said, here is the statement. And in the case of at least one of my clients, those are, for example, the term white supremacist KKK cop is used. Now, so that left the trial court to answer, is that First Amendment protected speech? When someone suggests that someone is a white supremacist KKK cop, is that a false statement of fact? The answer that the trial court came up with, quite correctly, was no. You cannot determine. Nobody can tell me what is in a person's mind to make them a white supremacist or not. Judge Krause.
Here's my question on that. A false statement of fact, is that make it absolutely an opinion, or can it be a false statement of fact and not necessarily be an opinion?
Well, the way the courts...
In other words, what I'm trying to get to is, do we need to even get to a determination of opinion?
As to whether the statement was factual or not.
Well, in other words, can it fail as a false, that it is not a false statement of fact, something that can be verified as a false statement of fact, and never get to the analysis of whether it is an opinion or not? Or is it all encompassed into opinion?
It's a good question. It's a good question, and I think they're closely related.
It's a very technical question.
Yeah.
It's really splitting hairs.
It is, and it also depends. I should mention that there are two layers of protection that each of the defendants enjoy here. One is under the federal Constitution, under the First Amendment of the U.S. Constitution. The other, the Ohio Supreme Court has separately held that opinion is protected separately under the Ohio Constitution. And so, Judge, I think to your question, I think the court has to look at it both ways. First, under the Ohio constitutional protection of opinion. Second, under the First Amendment. And I myself have asked I've asked in my head the question you asked there, whether the determination of statement of fact or false statement of fact precedes that. And what ultimately the way I've come to look at it is whether it is, and the opinions that have made this most understandable to me typically are whether something is ascertainable as true or false. And when you look at the statements that the plaintiff was good enough to put in the complaint, that's what the court must look at. None of them are susceptible to a determination that they are true or false.
You see, and that's it. If you're looking at whether it's ascertainable as to whether it's true or false, it seems to me, and that's what I'm asking your perspective on this. It seems to me that that could stand on its own and without having to get into whether it's an opinion. In other words, a complaint can fail because it's not ascertainable whether it's true or false, and not have to whether it's an opinion or not becomes inconsequential.
I think I think that's probably the distinction between the elements of the state law torts, which require the assertion of a statement of fact, versus separately constitutional protection, which is separate and independent. So I would, under the one way you framed it, the complaint would have failed to allege an element of the tort, and on the other hand, it would still enjoy constitutional protection that may supersede even a compliant complaint.
Okay, and then I want to get back to the filing of the complaint. And so the record is clear that the affidavit was attached to the request for the injunctive relief. I don't think anyone has a different perspective on what the record shows with regard to that. So the question becomes whether that affidavit is also part of the complaint, or whether it's not considered to be part of the complaint. Can you address that?
I think we had to assume it was not, for purposes of the, and by the way, Mr. Serkin and I weren't on this case at the trial court level, so we can't address some of the things that happened there. But I think Rule 12 commands that the court limit its view for purposes of the 12b6 motion to the four corners of the complaint. Nowhere in that complaint do I see a provision that says the provisions of the contemporaneously filed affidavit are incorporated herein. That would have been a very easy way for the plaintiff to communicate that they intended to incorporate that. They didn't, so I think that for the court's 12b6 analysis, we look just to the text in the complaint.
Thank you for responding to that. I really appreciate it.
Okay. With apologies to my co-counsel for the use of
You have about
time.
five minutes remaining. However you want to use.
5 minutes remaining?
5 minutes
I'll move
remaining.
as quickly as possible, Your Honor.
Okay.
Thank you. Also, apology to all counsel for maybe being caught in traffic and having to slide in at the last second, and to all of you. Judge Zayas, if it's okay, I want to start directly with you and your question, because I think Ms. Neeson's case is most indicative of your concern regarding this affidavit and the question of 12b6 within the complaint.
Well, I guess I'm not aware of anything. Is there anything in their appellate brief that's saying we need to consider things that were in the affidavit but not in the complaint?
No.
Okay. Then how does the affidavit change the analysis that we're looking at under the complaint?
And I'm going to leave kind of an open question because it is a strange thing. If we look at transcripts of the proceedings, documents 10 and 12, document 10 is an entry of the court saying, upon motion to file under seal and under a pseudonym, I'm admitting this affidavit and the materials attached to it. all of it was filed in kind of a jumble of motions and everything. And I think that through this process, it was never clearly set out at the trial court level whether that went through it or not. And it's particularly, I'm glad to be here to address this question and to address it in regard to Ms. Neeson, because what the trial court found for Ms. Neeson was that it doesn't matter either way. If we look at the complaint, all that is alleged is that she portrayed him as a white supremacist. And that's paragraph 25 in the complaint. That, as we've heard already, and I'm not going to waste the time to go into, but it is opinion, because it cannot be established as either true or false with any amount of discovery, without any amount of anything. There aren't any additional facts as to Ms. Neeson that could be alleged. The second part to that would be paragraph 20 in the complaint. They've already made it clear. It's an opinion themselves by saying that that hand signal is juvenile, unfounded, incorrect, and hysterical, and innocuous. They've already made it an opinion themselves, and a difference of opinion. And that's where the gatekeeping of the trial court comes in. The gatekeeping that starts with New York Times v. Sullivan and works its way all the way through all of its progeny, that where it is a question of opinion, in a case of a public figure involving actual malice, the analysis is at an end. There is no defamation, there is no claim. That applies to Ms. Neeson, and that applies to all of the other defendant appellees here. So, whether we look at it as what's in that attachment and in that affidavit by Ms. Neeson, strictly factual statements as stated by the trial court, or whether we look at it just in the light of the four corners of the 5, 6, 7-page complaint. They've made it an opinion in paragraph 20. They, as to my client, have simply said he's a white supremacist, which we know is an opinion based on all of the case law that has come before. And we can limit it here based on that. And you're, of course, welcome to look at the record and look at 10 and 12 and make that decision as to whether or not those were attached. But that loops back to the question of certified complaint and Rule 12 and its relation to Civ Rule 7A and all of that. And I don't want to get into those weeds unless you want me to, because Mr. Whitaker hasn't had an opportunity to address the court yet. So I'm going to step back unless there are any other questions from the court. Thank you.
Thank you. Mr. Whitaker, you have about 2 minutes remaining.
Thank you, Your Honors. My colleagues have succinctly tackled 12b-6, the First Amendment, and whether certain statements are opinion versus fact. The trial court found all of the statements by all of the defendants, appellees in this case, were either true or statements of opinion, and therefore, as a matter of law, this goes back to the gatekeeping function, cannot have a defamatory meaning. That's the first fatal infirmity to the complaint. If there's no possible defamatory statement, there is no defamation, the case fails. Second, Judge Shanahan correctly found there's no allegation or suggestion of actual malice. Throughout this matter, the plaintiff appellant has argued the defendants made statements intended to harm, intended to smear, intended to hurt, intended because they disliked police officers. That does not rise to the level of actual malice. Actual malice must be made with falsity or reckless disregard for the truth. Those allegations were not made in the complaint. We looked to the four corners only. They were not made in the complaint, nor were there any facts suggesting actual malice for any of the defendants.
Well, so could they just say the magic words, or would they have to?
I think at a bare minimum, you have to recite the mandatory elements of the claim.
Well, that would have been good enough.
It might have been, Your Honor, but it wasn't there. And I think for the gatekeeping function of the trial court to ascertain whether or not is this statement capable of having a defamatory meaning, because we have the First Amendment, are there any facts whatsoever suggesting actual malice? So in this case, because the First Amendment is so important, we don't want these frivolous defamation cases sneaking through the court.
But what is, like, from a pleading standpoint, do they just have to allege the statements were knowingly false or made with reckless disregard to falsity, or do they have to allege kind of specific facts underneath that are presumably going to be solely within the defendant's heads, right? So, like, what do they have to allege to survive a 12b6 on that?
And Your Honor, that's a good point, because when we have a public figure, we want there to be some sort of factual basis underlying the complaint to bolster this allegation of actual malice. That is the gatekeeping function of the trial court. I think there's disagreement as to whether how much factual statements need to be in the complaint, because Rule 8 does provide for the short and plain statement. But when we're talking about the First Amendment and actual malice, first of all, it wasn't pled, so it's not there. The bare minimum isn't there. When we're talking about the trial court's gatekeeping role, there needs to be some sort of factual underpinning suggesting actual malice. That wasn't there either. With all of this said, I just want to briefly touch on Appellate Rule 12, which requires the appellant, as the master of the docket statement, to recite specific portions of the record that would allow the Court of Appeals to find error with Judge Shanahan's order. Without that, the Court of Appeals has to assume Judge Shanahan acted correctly, because there's nothing to review otherwise. The appellant doesn't cite his complaint once in his brief. He offhandedly refers to Judge Shanahan's order, but never in the context of 12b6, never in the context of the First Amendment, never in the context of actual malice. So under the technical standards of Appellate Rule 12, in the Fountain case, if your honors don't agree with our analysis of 12b6 on the First Amendment, the appeal must be dismissed under Appellate Rule 12.
You are at your time.
Thank you. Thank you, Your Honor.
Thank you. Mr. Gottesman, would you like to do a rebuttal?
Thank you very much. Given the ample time that you've afforded us today, I can be very brief. In preparation for today, there was a quote, "A lie can travel halfway around the world before the truth puts on its shoes." It's often attributed to Mark Twain. I think it was actually Jonathan Swift who said it. But that's what's happening here. And the lie was told by Terhass White. Don't be distracted by this argument that it's about whether or not he's a racist or a white supremacist. That is not what this case was filed about. This is about an allegation of professional misconduct by a Cincinnati police officer throwing a gang sign, a racist gang sign, in a citizen's face at a public meeting. That's the lie. That's the lie that's gone halfway around the world. That's the lie that Mr. No seized upon, Ms. Gilley seized upon, Ms. Neeson seized upon. All of the defendants bought into Terhass White's lie. And it is ascertainably, provably, demonstrably a lie. Because there's video from the day, from City Hall, that shows it's a lie. It's a provable lie, and it's defamatory. Paragraph 62 says, of the complaint, says that the defendants have repeated this and they know it's a lie. So I think that I recognize certainly there's a tension between the First Amendment and this claim that this officer is presenting. And the First Amendment provides broad protections. But the First Amendment also has exceptions. And defamation per se, claiming someone is unfit for their job, and especially calling a police officer at this time in our society, accusing him of actual overt racist acts in the face of an African-American female intended to intimidate her, indicates not a matter of opinion. It is he would be an unfit officer. So Judge Shanahan, the complaint, I think appellees are being hyper-technical. That complaint covers a lot of territory. It definitely identifies social media posts by Terhas whites that they've repeated that they know to be false. And it's not that he's a racist or a white supremacist, it's that he's throwing racial hand signals in her face. And that's false. So
I guess I'm still struggling with the throwing in the face. Like, is that the actionable part, that it was done in close proximity to the person, or is it simply that the symbol was being made?
So
because I just don't see that in the complaint.
It is not. So it is not in the complaint that those discrete details that you've just mentioned.
Right.
But Rule 8 gives the plaintiff the benefit of all reasonable inferences to be drawn, and I think it's hyper-technical to require this plaintiff to plead all those specific facts. The affidavit of Officer Oldhouse is not attached to the complaint, and it is not within the scope of what a 12b6 motion analysis should entail. However, there is absolutely a reason to consider it because it brings forth the actual factual statement that lies at the center of this dispute. And it's that first page of Exhibit 3 to his affidavit, and I'm reading from it. What Ms. White wrote in this social media post was, a white supremacist KK cop named Ryan Oldhouse just taunted me by throwing up this OK white power white supremacist symbol after 2 citizen speakers were assaulted by a city council rent-a-cop named James Donaldson. So she's not rendering an opinion. She's telling a story. She's making up facts about an officer, accusing him of acts he did not take, which video would prove he did not take. Taunting her, throwing up those signs. First of all, there was no throwing up anything. He didn't even raise his hand above his waist. His hands were always at or below his belt. And there was no taunting. Taunting is an act.
But like, this case isn't about whether she was taunted or not. I mean, that's not the allegation, the complaint. I don't see how taunting can be defamatory.
I think that an officer accused of taunting a black citizen is absolutely within.
What does taunting even mean? Like, I guess
antagonizing.
But that's not
seeking to belittle.
But again, we're talking about something incredibly subjective here.
Well, and I'm not sure then that I think that ties right into my argument, because I'm not sure then that it's a 12b6 issue.
So are you saying that you would ultimately be able to prove that she knew the signal was not racist?
Yes.
That's the issue, right?
Yes.
Is labeling it as a racist signal or symbol or whatever, when knowing that it was not in fact so.
I think confronted with the video of this incident, she would be compelled to admit that he was not taunting her and that he was not throwing up a gang sign at her. I mean, the video is the video.
But would she be compelled to admit that she didn't interpret that as a racist signal?
She'd have to admit she didn't know his intent because she couldn't.
Well, she wouldn't know his intent. This is
Right.
about what she believed,
But that's why
her opinion of what it was.
Right, but that's why that aspect of her subjective consideration of it isn't the focus of our complaint. It's this description of an aggressive, abusive officer, taunting with racial signs. And that you know, everybody's concerned about that. Every officer is subjected to that sort of scrutiny on a daily basis. How their interactions with citizens are constantly scrutinized.
But it's really about the racial sign. I mean, right? That's the key.
I think that's a part of it. I don't think. Listen, take the racial part out of it. What if she just said, "This big cop was taunting me"?
Rude.
Yeah, taunting me and aggressive.
Is that
How is
defamation?
how is that defamation? How is that actionable?
So if it affects his job and it's not true and it's a lie, that has to be.
But I just don't understand how you would prove that or not, in terms of I'm talking to you right now, am I taunting you? Well, maybe you think I am, right?
I don't think you are.
But I mean, I think that is how that is an objectively provable fact or not, just is really hard for me to understand how that's the case.
Well, and so on a motion to dismiss under 12b-6, I think it's premature to let it go. I really do think if you allow the facts to play out in this case and you look at the videos and you say, wow, that's not even close. That's objectively, provably different than what happened. And it had adverse employment implications. And she made knowingly false statements because she was there and she did it. And there's no doubt about her intention to injure or antagonize a police officer. You can tell that by the recordings that were made that day. So, again, this is a 12b-6 analysis. I think that the court acted prematurely. I think the plaintiff should have been entitled to develop his evidence and present his case, and that the hyper-technical scrutiny on a 12b-6 motion, it's not the standard. We're required to give a plain and simple recitation of the facts that provide a basis for relief. The question before you all is simply, is what happened to Officer Oldhouse okay? Is it okay that he had to enjoin someone from disseminating his private information? Is it okay that he was falsely accused of conduct he did not engage in and then lost his preferred assignment? I think that the First Amendment allows inquiry into those issues. And I'd ask the court to reverse Judge Shanahan and remand this for further proceedings. So thank you all for your kind attention.
Thank you. Thank you all for your arguments today on this very interesting case. The case is now submitted, and we will issue a timely decision. And we will continue with the second case on our Zoom feed. Thank you.
Thank you.
All right.